Welcome to the Disability Approval Path.
Welcome to Social Security and Disability, the Approval Path with Ms. Deborah Spector, lead attorney and managing partner at Spector and Lenz, and your guide through Social Security disability maze. I'm Evan Mack, and today we're digging into how medical records can make or break your disability claim. This is how to strengthen your disability claim with medical evidence. Welcome back, Ms. Deborah.
Thank you, Evan. Good to be back with you.
Awesome. So listen, right, brass tacks, why is medical evidence so critical in your disability claim?
Oh, man, medical evidence, and don't let me get out without mentioning this, school records are
Okay.
Willy Wonka's golden ticket in Social Security cases. These things turn on medical evidence. The statute, the law Congress passed decades ago says you need a medically determinable impairment. So an allegation that, I'm really depressed and I can't get out of bed and I'm not showering and I'm not feeding myself and I'm disabled by depression, I need a doctor or a therapist or somebody who has evaluated and done a professional diagnosis, prognosis, statement of functional limitations. I think I have arthritis because I see twisting in the bones in my finger. I need a doctor. I need an x-ray, right? Medically determinable impairments, key. So medical evidence is the key to these cases. They turn on the medical evidence within, hundreds of rules and cases, but they turn on the medical evidence. Critically important.
But what kind of medical records does Social Security look for typically?
Oh my goodness, they look for hospitals, clinics, emergency rooms, podiatry. They'll look at chiropractic records. They don't consider them the same way they consider a physician or an osteopath. They look for psychiatrists. They look for licensed clinical social workers, more and more advanced practice nurses. They want credentialed people who are professional in the fields, who have administered tests and come to conclusions about what's wrong. And they love what we call imaging. And that's ultrasound, X-ray, MRI, CT scan, PET scan, things that can show us in black and white, cardiac testing, catheterizations that show where there's blockage and the degree of blockage. The more objective the testing, the easier it is to evaluate the claim. Now, in some conditions, you're not going to have that kind of testing, right? Like in depression. A professional can diagnose depression. There are clinical signs and findings. There's kind of a cookbook. Do you have this, and this? Well, that's major depressive disorder, but it's not quite as easy as looking at an X-ray or a blood test. And so there's a little more subjectivity, and actually mental health cases are among our most difficult. We do a lot of them, and they're difficult. Same thing with pain. As a general rule, pain can't be seen. It can't be measured objectively on a test. We wish it could. But with pain, we look for consistency of reports in the medical records. Do you go to your doctor time after time and say, I had that back surgery and I still have burning pain in my back and it's radiating down my leg? And we remind our clients, once they retain us and are working with us, make sure when you go to your doctor, you tell the doctor everything and make sure it's written down. The example I use is if you go to the doctor and you're missing a leg and you go in because you have bronchitis, the doctor is not going to write down, oh, by the way, missing a leg. Right? So it's incumbent on the patient and the Social Security claimant to make sure she's telling the doctor all the time, this is what's going on. This is what's happening, and that it's written down.
But how far back should records go? Is there no limit? The longer the better? Is there, or just records in general?
It depends on what you're trying to prove.
Okay.
So let's say you have a guy who's working as a bricklayer and he's working for years and he's doing fine. He's in otherwise good health, sees his primary once a year. His knees give out, right? So you might have medical evidence for 4, 6, 12 months prior to the time he stops working, showing he's going to the doctor saying hey, my knees are killing me. And the doctor does an x-ray and says, oh, you bet, you're bone on bone, right? We want that, even though he's still working. And then certainly from the alleged onset date, and usually we go 3 years prior. So when we take a new client, we usually say, tell us who you've been treated with over the last 3 years. Doctors,
Mhm.
hospitals, clinics, everybody. In some cases, pardon me, we have to prove that someone became disabled quite a few years ago for a variety of reasons having to do with when they last paid taxes. And then we target that period of time. Our firm represents a lot of people, young adults with spectrum disorders, mental health disorders, borderline intelligence. And in those cases, we say to the moms, go all the way back.
Hmm.
I want that first contact with Easter seals when your kid was 3 years old. And I
Hmm.
want every IEP. Those are individualized educational programs done by the school system. I want every IEP and I want every test because then we build a bigger case. We like to overbuild. You know, the government, if you are not represented or you don't provide your own medical records, the government will generally go back a year.
But Ms. Deborah, but do you need to submit from every doctor you've ever seen since the beginning of time?
No. Um, so, a couple of things come into play there, Evan. One is that we operate, and certainly we operate, under an all evidence rule, and it's by law. If I'm handling somebody's case, I am legally and ethically obligated to disclose all medical care and either provide the records or let the government know where they are,
Okay.
right? However, I don't go back, let's say, in an arthritis case with a woman who's had normal mammograms for 20 years, I don't have to go back and get those, right? They're not relevant. On the other hand, if I have the same woman with terrible arthritis and she's also been in substance abuse detox, I cannot, would never say, well, let's just forget about that, right? I'm under an obligation to disclose that. And then, as her representative, to try to explain either it has nothing to do with her disability, which is based on arthritis, or please look at her in a combination of impairment sense because that
Mhm.
substance abuse was based on a terrible depression that she was self-medicating and she's sober now. So it really is, that was a long-winded way of saying case by case. It depends. Yeah. Let me
But
add this. I have
add it.
someone who's been working with me for years, 100 years. And this woman, I adore her. She kind of runs the office and she is black and white. You did this in this case. Why aren't we doing it in this case? Black and white. She's been with me forever. And she cracks up because she'll say, well, why are we doing that? And I'll have to say, it depends. And so these are really case by case decisions. But as a general rule, you bet. You need your medical records. Go back at least a year, 2, 3 before onset rather of the disability, depending on the condition, and everything has to be disclosed. One more thing. Onset of disability is not the same as onset of the condition or
Mm,
diagnosis of the condition. Onset of disability means the date on which, because of your conditions, you couldn't work. Quite different.
okay. So,
Okay.
so Ms. Deborah, like, can you get, does it look bad if you kind of like go to a doctor when you know there's some you might have like this, you're trying to make a claim, so you kind of go to the doctor real quick to kind of try to get a medical record because you don't have any medical records that say the one thing that you're trying to claim. You know what I mean?
Well, yeah, sure. But what else are you going to do? You know? So if there's nothing, then of course, or frequently, this happens at least once a week. I'll have a client say, um, I had to stop working because my knees gave out and I can't do it. Have you been to the doctor? No, I told my primary. Have you been to an
Mhm.
orthopedist? Well, no, not yet. And I'll say, get your tush to an orthopedist and get some x-rays and find out what you need. And if that guy needs knee replacements, he's disabled, right? Even though he goes and I don't care if he says to the doctor, some woman, my disability lawyer said, I need an x ray. No, it doesn't look good. But if that's how we build the case, we build the case. We have federal judges who have said in their opinions that when a Social Security judge discounts evidence because the client came in to generate it, the federal court will say, well, of course he did.
Right.
How else is he going to prove this case to you guys? And an area in which we frequently tell people, go get yourself evaluated, is in the area of psychological impairments. And we tell people, go get what's called a neuropsychological evaluation. It's objective, it's expensive, it's thorough, and it will give us a good clue about what's going on with you. And of course, it's generated for this purpose. Yeah. So I'm a little, I might take a different approach than some lawyers about it. I say, yeah, go get the evidence. I don't care how it looks.
So, Ms. Deborah, you talked about it in a different episode about personal statements. What about a personal statement from a doctor? Do they carry the same weight? Can they be
That's
helpful as
different.
well?
That's not a personal statement. That's a
Yeah, yeah, yeah,
medical
yeah.
source statement. Right.
Hmm.
We call those medical source statements. They are opinion
Mm.
letters or opinion checklists from your treating doctor. Those are golden. If
So the
they
one, so what do you feel carries more weight though, Ms. Deborah? Like you personally, your account, because you're trying to get something, or a doctor who has treated you that kind of gives kind of a similar take.
Oh, totally the doctor. And frankly, Evan, your personal statement doesn't carry a lot of weight through
Mm.
the administration's levels of adjudication. Where we find it carries weight is in federal court. So that when a court is reviewing the whole picture and they say, hey, what about Exhibit B12, where this woman said she can't walk more than half a block without sitting down, and the judge disregards that, but the judge isn't going to be moved by that. We put those in so that anything the client doesn't have a chance to say through oral testimony at the hearing is in the record. But the doctor's statement is crucial. There's a
Mhm.
huge body of case law on how Social Security has to weigh the doctor's statement, what they have to do with it, what they have to do with conflicting doctor's statements. Up until a few years ago, although, gosh, now it's like 10 years, up until 2017, I think, the doctor's statement carried the day. If you had a doctor's statement supporting your disability and there were medical findings supporting the doctor's statement, your claim was approved. That's no longer the case. Now your doctor is weighed along with the other doctors. But if you have a doctor with a long treatment history, who is thorough, who's done all the testing, who then says, hey, I know this guy and he's credible and I believe him and I don't think he can sit for more than 2 hours during an 8-hour workday, that's tremendous evidence. That's the best we have.
Well, what about family members or employers? Any statements from them? Can they support your case as well?
Well, two different things. Family members, just like the claimant herself, that's icing on the cake. We want that in for federal court. Employers are a different story because sometimes the case will turn. Remember those 4 steps? Are you working? Do you have a severe impairment? Yada,
Yeah.
yada. Okay. Question 4. What is your residual capacity and how does it compare to your past work?
Okay.
Well, we need to be real careful about what we define as past work, right? A guy could come in, I'll give you an example, and say, you know what? I'm a supervisor at Walmart, right? Well, what
Mm-hmm.
does that mean? Does that mean he sits at a computer like you or I? Does he set schedules? Does he have hire fire authority? Well, when I press the guy, no, he's in charge of a crew of 4 and they're out there stocking shelves and he's out there with them
Right.
lifting boxes that weigh up to 50 pounds. That's not a desk job. So sometimes we need a statement from the employer identifying the job. Sometimes we need a statement from the employer saying, you know what? Remember step 1, are you working? Well, sometimes we can have a workaround around that if we can prove that it's a subsidized job, that they're letting you work even though you're really not worth what they're paying you. And for that, we need a letter. It's actually a form filled out by the employer. I love Evan's kid and I love him so much that
Mm-hmm.
I'm letting him work in my factory, even though he's not worth 50% of what I pay him.
Mm.
That's crucial. Employers can be crucial, right? Or employers can document, or coworkers, you know, John kept trying to work even though he was in terrible pain, and we
Right.
used to help him. we would step in and lift the boxes for him. Yeah, we love that evidence. Right.
Wow.
Very helpful.
So what's the best way to make sure your life is your file is complete and compelling? Is it just to keep a record yourself, talk to someone like you? Because I know like records can be hard to do. They're tedious, you don't get to them, but what's the best way to make sure you can do that?
Sure. Well, it's multifaceted. There's no one best way.
Okay.
If you're dealing with a qualified representative, the representative should be questioning you several times during the course of the case. Where have you been treated? Where are the records? Who are you being treated with now? Tell me whenever you go to a doctor, have a new test, have a new diagnosis. Keep feeding me records because this is a moving target. You have to prove it up to the date of adjudication. So if you have a good representative, the representative should be guiding you through that system. Now,
Okay.
Social Security, when you apply for benefits, will send out a sweep electronically for your medical records, and they'll get most, some, not all. For example, the neighborhood clinic, the guy in the strip mall who's your primary, may not have electronic records. Loyola University Hospital absolutely will. So it's a mixed bag. You have to make sure that they get everyone, even those who do not use medical records yet. And that's the claimant's obligation or the lawyer's obligation to the claimant's represented. How do we know if they have everything? Well, without going too far into the weeds, we have electronic access to all of our files once Social Security recognizes us as the representative. And I go into those cases, not every case every day, of course, but I go into those cases every day. I go through a certain number of them. I go through anyone whose status has changed. And that software will tell me what records they have, what records they're still requesting. And then we have our own software that tells us what records we've requested, and my staff will record when they are received and will electronically submit them to the government. The name of the game is getting the records to the government. They do no good in a shopping bag under next to your TV. They have to be submitted to the government.
Miss Deborah, thank you so much. It's a pleasure.
Well, it was a pleasure, Evan. Thank you.
Your medical records are your voice in a disability case, so make sure they speak clearly. For more tips and answers, follow Social Security Disability, the approval path, and connect with Ms. Deborah at spectorandlens.com. Don't forget to like, subscribe, and leave a review if you found this information helpful. Thank you so much for tuning in.
Thank you, Evan. Bye-bye. See you next time.
Bye, Ms. Deborah.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.